Hey guys, Quentin from Champion Briefs here. This is a topic analysis video for the February public forum topic covering the Rome Statute and the International Criminal Court. The resolution is resolved the United States should accede to the Rome Statute of the International Criminal Court. We're going to talk about what some of those words mean, starting with the Rome Statute and the International Criminal Court, which we're going to call the ICC from here on. I can't say that over and over. You shouldn't either. The Rome Statute is just the statute that actually created the International Criminal Court. Before this, there was no international governing body or international justice system. So the Rome Statute was created and written, which then put into place the International Criminal Court, kind of established it. The crimes covered by the International Criminal Court are pretty specific. It's not just any crime. It's only crimes that can occur between two different states internationally. Those would be genocide, crimes against humanity, war crimes, and crimes of aggression. A lot of those are self-explanatory. We know what genocide is. Crimes against humanity are kind of atrocities that terrorize civilian populations. War crimes are pretty similar: inhumane treatment of civilians during war and times of war. And then crimes of aggression are those situations where one state is invaded by another state. Pretty specific set of circumstances for the ICC to get involved, but before the Rome Statute was put into place, before that treaty created the ICC, there was no international body to cover these things, so that's what it was created for. Now, accede is a very special word. It's a very particular word. It pretty much just means, in this context, to sign or ratify or join in with the Rome Statute. In this instance, in this resolution, I don't know why they chose accede. Using that word is kind of weird and may, in some instances, create some room for weird definitions. But I think for all intents and purposes, we are talking about ratification of the Rome Statute by the United States. I think it's a reasonable interpretation of the phrasing that's used. In a definitions debate that comes to a different conclusion of what accede means in this context is pretty unlikely. So for all intents and purposes, accede can be used interchangeably, and I'm going to be using it interchangeably throughout this when talking about this as something like ratifying the Rome Statute. So effectively, what this resolution does is has the United States, which is currently not a party to the Rome Statute, accede to it, ratify it, join as a party state or a signatory state, so that they can be included under the ICC's operations. So a couple of top level general ideas about this topic. Framing is going to be very important. In something like this, where it's international bodies, everybody outside of the United States thinks that the United States should ratify and join to the statute. Everybody inside the United States thinks that it would be awful for us. What does that mean? It's just something to think about broadly on the subject, kind of come to your own conclusions about what's right and wrong there. But, with these kinds of things, we're going to talk a little bit later about how, with international topics like this, it only works when everybody joins in, but nobody wants to join in. So it's just something to consider on this. Now, if you're debating on a circuit that does big stick impacts, like debate rounds where it's, a race to extinction type of debate, the pro side might be stronger on this, because on those circuits, there is a lot of international impact consideration. On the other side of the coin, if you're on a circuit that's more grounded in typical lay debate, like real world impacts, or the type of style of debate that's, talking to the judge and having them picture what their life looks like in the pro world versus the con world, in those types of debates, con might be stronger because they're more focused on what's good for the United States rather than internationally. And the last thing to consider before we dive into some arguments, just kind of a broad thing. While I do think that this is a good, relevant, important topic, and something that should be thought about by debaters especially, In a debate context, it's going to be a little bit tough to impact out these arguments fully, or as much as we typically would like to, as much as we're used to. Things are going to get messy and kind of convoluted as you work your way down the internal link chain from the initial claim to the final impact, whatever that would be. When we're debating, and most of the impacts we're used to using and arguing are extra legal, kind of outside legal bounds like war, they are hard to access on a legal topic like this. So our usual like economics or war, whether it's nuclear war or not, those kind of impacts can be difficult to get to from what is effectively just signing a piece of paper. Or at least it's going to be hard to get to those impacts without some suspension of disbelief. So that's kind of why I talk about what circuit you're on a little bit. I could be wrong, of course, but I would expect a large majority of rounds on this topic to come down to more ethical bases, focused on, kind of abstract ideas like justice and those kinds of related things, rather than, it triggers war, as we, can access a lot of times on a lot of topics. Now, it's funny to say that and then dive into the arguments, because the first one I'm going to talk about kind of can access that. Let's look at the pro side first. We're going to look at the first argument, which is conflict broadly, but within the context of current conflicts like Israel and Gaza, and Russia and Ukraine. Starting with Israel and Gaza, the ICC is currently trying to investigate and possibly prosecute both Israel as a government and Hamas for the ongoing conflict that's happening in Palestine and Gaza. Now, American opposition to this is making it super difficult for the ICC to gain any traction or make any progress in these efforts. And when I say American opposition, I mean both to the ICC as a body, as a functioning organization, and also American opposition specifically to them investigating Israel, because Israel is a very strong, longtime ally of the United States. So the argument here is that American accession to the Rome Statute or ratification of the Rome Statute would help with that investigation process. It is one way that you can access some sort of United States war impact. There is a scenario with the conflict with Israel and Gaza where the United States could get pulled into it in some way. It has started spilling over into other states with Iran and everything. So there are situations, realistically, where the United States could get pulled into this conflict as a result of it continuing. So if accession to the Rome Statute would make it easier for the ICC to prevent the conflict from going any further or getting any worse, it would be feasible to make an argument or have an impact of avoiding the United States war. The same kind of story goes for Russia and Ukraine. American opposition to the body itself, in this instance, the United States doesn't have a super strong ally like they do with Israel, but America is still strongly opposed to the ICC itself. That hinders its ability to deliver justice. So the United States joining or ratifying or acceding could assist in deterring the conflict in Ukraine from going further. So again, there's an option here for a pretty big war impact. An argument in this vein is probably the clearest route to a material impact for the round. Kind of as I mentioned earlier, a lot of debates are going to come down to abstract ideals like justice or things like international order, which we'll talk about in a minute. And those things do have very solid impacts that you can use in the round. But in my opinion, the clearest and most immediate material impact that we're used to is going to be found somewhere in one of these ongoing conflicts that ratification could potentially play a part in ending. Moving into the second argument that I want to talk about on the pro side is international order. Very vague term. We're going to split this into two parts. The first is international norms. Now, this can be described as the idea that progressive or hegemonic powers like the United States pledging to enforce the Rome Statute sets a precedent that other countries will follow on to. International law sits in a strange place where being subjected to that law is kind of voluntary. So the Rome Statute is an agreement that says, if I do something wrong, one of those things that we listed earlier, I agree that I should be punished for it, and you will punish me for it, I'm agreeing to that. Nobody wants that for themselves, but everybody wants everybody else to obey it and be punished if they do something. The person agreeing to be punished by a set of rules doesn't actually benefit them at all if nobody else agrees to those same terms. So the United States, as one of, if not the most powerful country in the world, refuses to be subject to international law. International law is weakened as a result. Therefore, if the United States accedes to the Rome Statute, it sets a very high standard and strengthens international law as a byproduct of that. Strong international law, of course, has a ton of benefits, one being that it acts as sort of a conflict filter. The stronger international law and norms become, the less likely it is that conflict breaks out, especially between those countries that partake in those international norms. So the more countries that do that, the less likely conflict is, and so on. That's one way to approach this kind of international order argument. The other way is about U.S. values and kind of the rules-based international order. What does that mean? It doesn't matter. We'll focus on the values aspect, because this is, whenever you start getting into things like geopolitics and international order and things like that, you start getting into a lot of different words and phrases that, frankly, nobody should have to know what they mean. So U.S. values. U.S. values include things like the expansion of democracy, or its strengthening, strong flows of economy, human rights, and so on. Things that, as a hegemonic power, we think benefit us and the rest of the world. This argument says, effectively, that the U.S. acceding to the Rome Statute would help integrate those values into the international order and other countries as a result. So this argument can be a strong internal link to democracy, economics, human rights, and once again, of course, reducing or preventing possible conflicts. Because if we, as a very strong country that has refused to be part of the ICC and the Rome Statute for so long, decide that we will join in, we will have a lot of power in that organization. Could be a good thing, could be a bad thing. But in this instance, it would hypothetically give us the power to kind of integrate the things that we see as beneficial, like democracy and strong economic pathways, kind of into that international system that could be pretty beneficial. Now, I do want to make one thing clear. I made a big old fuss right at the beginning about how there's not a lot of material impacts like war and conflict like we're used to. And then I brought up like 6 times different ways that you could, prevent war. I want to be clear that the nuance there is that typically, we have these topics where there is a very clear current conflict or current possible conflict that could occur, and we have a way to link whatever we're saying we want to do to preventing it, or vice versa, that if we do this thing, it causes it. And we have pretty specific evidence. We have a time frame, we know who's involved and when and where. In these instances with things like international order and international norms, things that I was talking about kind of helping prevent conflict, those are very broad stroke assertions. And these are ideas that theoretically say if international law is strong, there will be less conflict. We can't say that there will ever be conflict again. We can't say specifically that it will stop conflict between the United States and China, or whatever the example is. That's why it's a little bit weaker than something specific, something that you can actually hang your hat on with names of countries and being able to describe specifically what the conflict is or where it stems from. But still, it is a strong impact that you can use when talking about things internationally. The last argument on the pro side that I want to talk about is pretty self-explanatory. It's going to be justice for war crimes. I know it's super surprising, right? The United States has done some very bad things. Actually, in fact, by some estimates, the United States is a leading committer of war crimes. By not being a signatory state to the Rome Statute, no justice can ever be served for crimes committed by the United States. And that lack of accountability makes those sorts of crimes more likely. It just makes sense that, if you know that you won't be punished for doing this thing that is bad, you are more likely to do it, most likely. At least that's what the evidence shows, and that's what history shows. So this is one of those kind of abstract justice impacts that you can use. If the United States ratifies the Rome Statute, they would theoretically be subject to the laws of international order or international laws for war crimes and things, which would make them way less likely to be committed in the future. Let's look at con now. We've got, again, 3 arguments. The first one is going to be a very broad stroke. The ICC is a flawed system. This argument can be made a few different ways. Either that the ICC is just such a poorly structured system that it will never actually work for its goals with or without the US, or that the ICC has such bad flaws to it that it's actually a harmful system that should not be joined or supported. The first option is that it just doesn't work. So factors like its geographic location in Hague in the Netherlands makes it pretty difficult to do what it does, investigate and gather evidence and prosecute crimes. In terms of operation, the ICC also accepts voluntary funding, which is thought to create biases and risk, selective justice, which there's a ton of evidence about. So the idea with this argument is that if the court itself can be manipulated and has fundamental flaws to its system that prevent it from being able to, investigate even when it chooses to, the argument that the pro is going to make that U.S. refusal to accede is the only roadblock gets a lot weaker. It's important to remember that in these debates, the status quo is always the default option until pro shows that a change to the world would be beneficial, and that makes that job a lot harder. If we can show that the ICC doesn't actually do anything, it doesn't work whether the United States joins or not, it's a harder sell to say that the United States joining would change all these things. Now, one could also argue that some of those factors actually make the ICC a bad system. Not bad in terms of effectiveness, but bad in terms of should we support it or not. There are a few arguments about how states choose to refer cases to the ICC. The ICC prefers that states decide when a case should be investigated. But this allows for pretty severe weaponization of the system for political or military gains rather than actually seeking justice. For example, if the Rome Statute allows me to bring a case against a country that I'm in conflict with, that translates to a lot of bargaining power for me within that conflict, and even more military success in some cases. That leverage is created from nothing. That leverage wouldn't exist without the ICC and without the Rome Statute written how it is and how it operates. So this can turn pro arguments on their head. If pro wins that U.S. accession to the Rome Statute strengthens the International Criminal Court, but con wins that the International Criminal Court is actually harmful to justice, a pro ballot becomes a lot tougher to sign my name on as a judge. So this is a way to kind of, turn those pro arguments, and as the con side, there's not a ton of reasons, at least at first glance, surface or face value, why should the United States not join, rather than, refusing to critique the United States and its actions. You can choose to critique the specific form of justice or route to justice that the pro side would be advocating for. Now, the second argument I want to talk about is peacekeeping. You cannot have an international topic, especially one that relates to the United Nations, without some peacekeeping arguments. As a totally voluntary international force, international relations and state relations, states' relations with the United Nations governance bodies can definitely be affected by the resolution. The U.S. has taken a lot of large steps to protect peacekeepers, specifically its peacekeepers and peacekeepers from non-party states, to protect them from prosecution. But accession to the Rome Statute would undo all of that work, making those volunteer forces prosecutable. If peacekeeping operations become perceived to be more harmful to the United States and its power than helpful, we will absolutely pull our forces and our funding from peacekeeping operations. We've done it in the past. The Security Council, the United States member, in the Security Council has vetoed resolutions specifically because they didn't protect peacekeepers from International Criminal Court jurisdiction. Now, this is important because the United States is a very large contributor to peacekeeping missions, so it's important that the U.S. Views those missions and the organization that does them favorably. If the U.S. were to pull its funding for any reason, in this case we would say that reason would be, it would be detrimental to us, it would be pretty harmful to crucial operations that peacekeepers do. This can be impacted out to broad, war and conflict impacts, with the internal linkage being that peacekeeping operations are key to keeping conflict contained. That would be the story to tell there. Now let's look at the last argument, no flashy tagline, just that it won't change anything. It's tough to even know where to begin on this. So as we talk about this argument, picture like in big flashing lights up here and like tattooed across my forehead, the words accession to the Rome Statute is not the same as compliance with it or with the ICC. The U.S. has and probably will again soon, based on things that Trump and the conservative members of Congress have said, sanction the ICC and its officials, which is a huge impediment to justice. Accession doesn't prevent that from happening. The United States also sits as a permanent member of the United Nations Security Council, which has a lot of power over the ICC and can veto some ICC investigations. U.S. accession to the Rome Statute doesn't take away its permanent seat, doesn't take away its veto power. The United States also has the American Service Members Protection Act that was written into law specifically to counter the Rome Statute. That piece of law is nicknamed the Hague Invasion Act because it gives the United States authority to invade the Hague, where the ICC is, if the ICC holds an American citizen or an ally of the states in an investigation or prosecution. This is obviously another massive impediment to the ICC that accession to the Rome Statute wouldn't do anything to prevent. So the story here is that accession doesn't actually lead to any functional changes. The U.S. can still and probably will veto any resolutions that they don't like related to court action. If that doesn't work, they can still sanction the court and its officials to prevent investigations and prosecution. If that somehow doesn't work, it's written into American law that states can, the United States can and will use military force to prevent ICC prosecution of Americans or allies. We can sign and ratify and accede to the Rome Statute until the cows come home. It doesn't change our sanction power, our Security Council veto power, or our military force options under the ASPA. The U.S. and its allies will never be investigated fully. They'll never be tried. All of that would happen is that the United States is now a party state to the Rome Statute, which doesn't functionally mean anything. Right? It's an agreement. The only thing that happens after that, ideally, is that if the ICC wants to investigate the United States or its allies, they comply. This prevents that. Accession doesn't mean compliance. So unless the pro side can access impacts simply from accession, the act of acceding to it, nothing after that, just the act of acceding to the Rome Statute, unless the pro side can access benefits through that or impacts through that, it makes it tough to access really anything. And of course, in that vein, we've talked about there are some arguments that even just accession to the Rome Statute, helping legitimize a system that could be harmful, is a bad thing. So all that being said, I hope you learned a little something from this. We talked about a handful of arguments on each side, but that's just a fraction of what's available in the Champion's brief release for this topic. So if any of this piqued your interest or you want to see what else is available in the brief and you haven't yet, I highly suggest at least considering it or checking it out. With all that being said, I appreciate your time and your attention, and good luck.